LLC and S&D Vortis LP.
Scott Hayes for third-party defendant Lasso Technologies.
All right, go ahead and proceed.
Your Honor, Christina Pierre-Louis for Griffin again. May it please the court, the Griffin defendants are here today because we believe that the Weatherly defendants are attempting to circumvent proper procedure by seeking a motion for summary judgment and simultaneously failing to offer its corporate representative for deposition. The basis for our continuance is that we believe there are three bases for the court to allow a motion for continuance for an MSJ hearing, and we believe that the length of time this case has been on file is our first, basis to discuss. The case has been on the record for some time. However, Griffin was not an original defendant to this lawsuit. Second, Your Honor, discovery is not set to close until December 22nd of this year, which the Weatherly defendants have agreed on, and they signed the agreed amended scheduling order. And further, the case was stayed because of Weatherly's bankruptcy, and also COVID-19 has prohibited us for some time this year in taking depositions. We have asked numerous times the Weatherly defendants to offer its corporate representatives for deposition. We've sent emails, which you can see as attachments in our motions, Your Honor, and they just failed to respond. And now, instead of responding to our request, now they're trying to circumvent procedure and by stating that our third-party cross claims against them are insufficient. However, Your Honor, that is not the proper basis for an MSJ hearing. It's proper for a special exceptions hearing. And now we do agree we made an error in our response stating that they did not file special exceptions. However, Your Honor, they did, and we asked the court to take notice of those. However, those were never set for hearing. So if they're stating, the Weatherly defendants are stating that our pleadings are insufficient, they should have set those for hearing, those special exceptions. And if those special exceptions were sustained, Your Honor, Weatherly, the Griffin defendants would then have an opportunity to amend its pleadings. It is improper for them to seek a motion for summary judgment based on insufficient pleadings. That is not the basis for a motion for summary judgment. We also filed a motion to compel Weatherly defendants corporate representative, which they have not responded. They've not given any good reason why they haven't offered their corporate representative. And by law, we are entitled to take that deposition. And we've sent emails, like I said, we've called counsel for the Weatherly defendants.
So
and
how long has your client been a party?
We've been a party, I believe, since 2018, Your Honor. My law firm was brought in as counsel at the beginning of this year. And as early as March of this year, Your Honor, we've asked the Weatherly defendants for their corporate representative deposition. They did not respond. I again asked in June via email of Ms. Bryant. She did not respond to that email. And then instead of offering their corporate representative, they now filed a motion for summary judgment, which again, as I argued previously, is improper.
Ms. Bryant?
That's a lot to respond to. In response to Ms. Pierre-Louis saying that I did not give any reason, I did give a reason to her on the phone. I told her that my client is bankrupt and I don't have anyone to present. That's the basis of why I haven't. They're very much aware, as Ms. Pierre-Louis said, we had this stayed for 3 months because my clients went into bankruptcy and the bankruptcy was lifted.
Well, you can't really use that as a sword and a shield, right? I mean, she's requested a corporate rep. You haven't given it because you can't find one. You can't now just move forward for summary judgment without giving her an opportunity to conduct discovery, right?
And well, Your Honor, the basis of my motion for summary judgment is on their cross-claim for proportionate responsibility. My client settled with the plaintiffs in April of this year. So therefore, we cannot be named as a settling defendant by law. So that is the basis of my motion for summary judgment.
And that's it? There's no other basis other than that?
No.
Why do you need a corporate rep for that?
Your Honor, Weatherly defendants took possession of this property soon after or the day of the incident made the basis of this lawsuit, Your Honor. they took possession of any equipment that my client installed. We don't know after the incident how that equipment was handled, what the basis of Weatherly and S&D's, relationship is. Again, we have requested this. It's material to our defenses during trial to get this deposition.
I'm not questioning that you might need someone to depose someone from the defendant, from the Weatherly defendants. I guess my question really is, why do you need it for this summary judgment?
Your Honor, I believe that she was the reason for the summary judgment, unless I am mistaken, Your Honor, was to dismiss them and then not ever offer up their corporate representative for deposition.
You can still take their client's deposition even if they get summary judgment. That doesn't preclude you from conducting discovery against them.
Well, if they're no longer a party to the action, Your Honor, we'd then have to do a third party subpoena if they're no longer parties.
Potentially, that's potentially true.
So we were trying to avoid that by offering their corporate representative for deposition. And I discussed with Ms. Bryant that if we could get that deposition, Griffin would then be amenable to dismissing our claims against them. But instead of agreeing to that, they've just gone ahead with this hearing. But I spoke to Ms. Bryant and I let her know that my client would then dismiss them if they offered this deposition. We've tried, like I said, we've been trying to get dates. They just haven't responded. And I understand that Ms. Bryant is saying that there's no one available, but that again is not a basis for a motion for summary judgment.
But that's not my basis.
Well, I mean, that's, one of the reasons you said that earlier.
Well, she said that that's, I mean, I share your concern that you had problems getting discovery from the Weatherly defendants. And I don't think it's a basis to say, well, we're bankrupt, therefore we don't have to participate in discovery. I don't think that's a basis to, if the bankruptcy court has allowed this to go forward, then their clients would have to be subject to discovery just like any other defendant or plaintiff or party. But I feel like we're kind of a little bit mixing apples and oranges here. Is there any discovery needed to respond to this summary judgment is kind of the first issue, and it doesn't really sound like there is. Then the second issue would be, which isn't necessarily set for today, is can you get discovery from this defendant? Well, surely you can. It's just going to be maybe a little more difficult. It sounds like Ms. Bryan is having some difficulty getting in touch with people who are affiliated with these defendants, but that she's obviously engaged in the case, so she's going to have to do that.
Your Honor, if I may respectfully respond, if we were to go forward with today's motion for summary judgment hearing, again, as I previously stated, if they're stating that our pleadings were insufficient, that should have been set for a special exceptions hearing, and you would have had to grant those exceptions and sustain them.
I'm not ruling on that issue. I'm just saying, should you get an extension right now? That's the question. And I handle these very consistently across the board, which is if there's a continuance requested and they're assuming there's been due diligence, which I think there probably has here, the question really becomes, is there any discovery that needs to be done prior to the summary judgment being heard? That's the only issue I'm looking at, and it doesn't sound like there's any discovery that needs to be heard prior to hearing the summary judgment. Now, is there an issue involving whether or not I should grant this? Should it be a special exception? I haven't ruled on that. Whether or not you're allowed to future discovery, I haven't ruled on that. It's just whether or not we go forward with the summary judgment today is either proper for summary judgment. I do think it's so bottom line, I'm going to deny the continuance and allow the summary judgment to go forward, and we'll hear argument on that.
Yes, Your Honor.
Thank you, Your Honor. May I proceed?
You may.
Your Honor, as I stated previously, this is a traditional motion for summary judgment on Griffin's cross claims against my clients for indemnity and contribution. And the indemnity claim is a common law indemnity claim, and it's proportionate liability claim, as the court's aware. My client settled with plaintiff in April. We finalized our settlement. And so therefore we are considered a settling person as a matter of law. And in my motion, I cited the Texas Civil Practice and Remedies Code, section 33.015D. And it states that a defendant has no right of contribution against a settling person. And then I went on to define the settling person as someone whose payments can be applied to the total damages recovered. And that is the basis for my motion for summary judgment. We are a settling person, therefore we cannot be a named defendant for contribution in this case.
Response?
Your Honor, again, my arguments are very much similar to the ones I stated before. Griffin holds that this motion is premature. There's outstanding discovery material to the issue presented in the motion, Your Honor. And then we also argue that the motion is procedurally insufficient because if they are stating that our pleadings, again, were insufficient, that was proper for a special exception and not a motion for summary judgment hearing. Civil Procedure Rule 91 states that. Powers v. Smith states the same thing, Your Honor. I don't want to beat a dead horse, Your Honor, but we presented these arguments, and it's only after a party has been given an opportunity to amend after special exceptions are sustained, which they have not been because Weatherly never set their special exceptions for hearing, may a case be dismissed or resolved by summary judgment. And that did not happen in this case, Your Honor.
Okay, let me just make sure it's clear, though. I'm about to rule, but I do want to make it kind of clear, which is I am going to grant the summary judgment. That doesn't mean that at trial, obviously, you'd be able to submit her as a settling party. That's well established in the Texas Civil Practice and Remedies Code, as well as the pattern jury charge. So I'm going to grant the summary judgment. That doesn't, and again, does not mean that you won't be able to conduct discovery against this party. Anything else we need to rule on today?
Nothing for me, Your Honor.
Your Honor, again, this is Christina. I'm not sure if you were ruled on the motion to compel. I mean, now that the summary judgment's been granted, I'm not sure.
The motion to compel the corporate rep deposition?
Yes, Your Honor.
I'm going to go ahead and grant that.
Thank you, Your Honor.
Your Honor,
When can you?
I apologize. In the motion to compel, they never provided us with corporate representative topics. That would be very helpful. I'm in contact with the bankruptcy trustee. That's literally the only person I can get in contact with. And if I have some dates, I'm not confident that I can get, or some topics, I'm not confident that I can get someone, but that would at least help me out a lot with a missing.
You need to provide her topics. She's absolutely right about that.
Yes, Your Honor, we will do that.
You need to provide dates for the deposition within 30 days after the dates for the deposition need to be within 30 days after she provides you the topics.
Yes, Your Honor.
And Ms. Bryan, I want you to provide an order on both of these orders, both for the summary judgment and the motion to compel. Make sure you get those emailed to my court coordinator.
I will. Thank you.
As well as e-filed. Okay. Anything else, guys?
No, thank you, Your Honor.
Thank you, guys.
Thank you.
All right, you guys are excused.
Thanks.
Thank you, Judge.
Hey, guys. Were you able to get signed on, Andrea?
Yes.
Okay, you were able to get the documents and everything? you there? Can you guys hear me okay? Oh, you're
I
muted.
thought I responded with yes. I don't
Okay.
know if you.
Yes.
Excuse me. Okay. All right, Julian, tomorrow, I just want to remind you, you have lunch. We're going to be meeting over at Avo Eatery. Let me just double check something real quick on a time. Actually, would 1 o'clock work okay for you, Julian?
Probably.
I'm sorry?
Yes.
Okay. What about you, Tara? Does that work for you?
I have a class from 2 to 2:30, so I may have to leave a little bit early.
Let me see if she can do 12:30.
I do as well, but I can make it work.
All right, so just so you know, our 2 o'clock hearing canceled. So I have to take care of something. I have to turn in some hours for my bar CLE. So why don't we reconvene at 2:15, okay? Oh, oops, and we were on YouTube.